Our last speaker is Assistant Professor Lorma Auria Cuadro. Ma'am Lor, as we call her, teaches general education courses offered by the department, such as The Contemporary World and Life and Works of Jose Rizal. An accredited human rights educator and researcher, she will discuss the rights of women, a topic she has also delivered in the School on the Air program of MMSU. The virtual floor is yours, Ma'am Lor.
Good day, everyone. I will discuss a specific topic on violence against women and their children. So this topic will provide you insights on how a specific act or omission be considered as an act of violence against women and their children. Although this topic emphasizes rights of women, this does not mean that this discussion on their rights should be attended by women only. Men are encouraged to listen to this endeavor in order for them to be informed of the specific acts that constitute as violence to women and their children. So before I discuss the specific acts that constitute violence against women and their children, let me present first the historical perspective about women. So we have the term here, babae. So ano bang tawag or ano ba yung pananaw nung unang panahon sa terminolohiyang babae? In this table, we can see the difference of the pre-colonial and colonial perspectives about women. Pre-colonial is the period before the coming of the Spaniards, while colonial is the Spaniards is the period when the Spaniards occupied and ruled the Philippines. During the pre-colonial, women are recognized to be endowed with civil and political rights. So as you can see there, they are being respected for their human rights, and they can even be heard for their maternal wisdom, and they were given the privilege to become rulers during that time. However, there was a total change in this view with the coming of the Spaniards in the Philippines. It was then that women are viewed as mimic, modest, and submissive. With this change, stereotypes were then considered with men and women. So because of the perspective that the Spaniards had about women during the early days, it gave birth now to the concept of gender role and gender stereotyping. So what do we mean by gender stereotyping? So ito yung usual na pananaw ng society pertaining now to the usual role that is being played by a woman or a man in our society. Okay, so Sandra Bem in 1993 has identified 3 common beliefs about women and men in Western society which have led to rigid stereotypes, and the Philippines unconsciously or even directly adapted some of these insights. So number 1, women and men have basically different psychological and sexual nature. Number 2, men are considered to be superior and the dominant gender. And lastly, gender differences and male superiority are considered to be natural. Since majority view women to be marginalized and vulnerable, several measures were passed to protect them. In the Philippines, we have RA 9710 or the Magna Carta of Women that provides for their rights, and the special law RA 9262 in which women can seek refuge to if abuses are committed against their person and against the person of their children. So we have here RA 9710, which is known as the Magna Carta of Women, which was signed into law by PGMA or President Gloria Macapagal Arroyo on August 14, 2009. Under this law, we have the following rights that are being provided. So the first one, the right to protection from violence, the right to equal access and elimination of discrimination in education, scholarships and training, and then the last one is the right to health. So these are the specific acts that you can see under RA 9710. So aside from the Magna Carta of Women, we have also RA 9262, also known as Anti-Violence Against Women and Their Children Act of 2004. So in connection with the right to protection from violence, this law has been enacted in the year 2004, And this law enumerates the different acts and even omissions that constitute as violence against women and their children. So this law will cater issues pertaining to domestic violence, since vow or violence against women continues to be a major social and public health issue. Historically, violence against women was not recognized as a human rights issue until the 1993 Vienna Conference on Human Rights. In the same conference, nation-states made a declaration to eliminate this form of violence. So from this one, they clearly identified that violence against women is based on gender inequality. So as mentioned, RA 9262 is just one of the legislations enacted for the protection of women. Aside from this one, there are some other laws that were promulgated for protection of women and persons, and these are the following. So the first one, we have RA 7877, or the Anti-Sexual Harassment Act of 1995, followed by RA 8353, or the Anti-Rape Law of 1997. Next, we have RA 8369, which created the family courts. And then we have also RA number 8505, Rape Victims Assistance and Protection Act of 1998. Next, we have Republic Act number 9208, or the Anti-Trafficking in Persons Act of 2003. And lastly, we have the first mentioned law, which is RA 9262. Now, let's go to the specific law, which is your 9262, or the violence against women and their children. So in this slide, we can see the definition of violence against women and their children. Violence against women and children is defined as any act or series of acts committed by any person against a woman who is his wife or a former wife. For the first act, or for the first definition, violence can be a single act or series of acts that could be committed against a wife or a former wife. So here, the perpetrator is a husband or a former husband. Then the second one, it is an act which is against a woman with whom the person has or had a sexual or dating relationship, or with whom he has a common child. For the second definition, against a woman with whom the person has or had a sexual or dating relationship, or with whom he has a common child, here the perpetrator is any person whom the woman had a relationship with or whom she had a common child. Number 3, an act which is against her child, whether legitimate or illegitimate, within or without the family abode. So for the third definition, it's an act which is against her child, and this violence could be committed against the child of the woman. Under our law, we have the definition of a child. So, a child is anyone below 18 years of age or even older, but this older person must be incapable of taking her or taking care themselves, including the biological children of the victim and other children under the care of the woman. So under RA 9262, they are the following: violence against women and their children could be committed any of the following. First, we have the husband or the ex-husband, by the boyfriend or the ex-boyfriend, the father of the woman's child, a lesbian girlfriend or a partner or ex-partners, and any person with whom the woman has or had a sexual or dating relationship. So now let's go to the different acts that constitute violence against women and their children. So the first violence or the first abuse is the physical violence. which is defined as any bodily harm or physical harm which is inflicted upon the woman or upon her child. So we have the specific acts. First, causing, threatening, attempting to cause physical harm to woman or her child. In here, there are 3 ways mentioned in causing physical harm to the woman or her child. First, that person inflicts bodily harm to the victim. Second, it could be in the form of threat or threatening to cause bodily harm. And lastly, there is an attempt to cause harm to the victim. Number 2, placing the woman or her child in fear of imminent physical harm. It means that the perpetrator exposes the woman or the child to a life-threatening conditions or situations. Number 3, attempting or compelling the woman or her child to engage in conduct which they have a right to desist from, or to desist from a conduct which they have a right to engage in. An example for this is you force the woman to do household chores despite the fact that he or that she is already sick and unable to perform such act. Number 4, attempting to restrict or restricting the woman's or her child's freedom of movement or conduct by force or threat of force, physical or other harm, or threat of physical or other harm. An example for this is setting a curfew does not constitute a violence. However, if the curfew has been set unreasonably to the extent that you restrict the movement of the woman or her child, and it is even coupled with a threat of inflicting physical harm, then this will constitute a physical violence against the woman or her child. Then last act, any act of intimidation that is directed against the woman or her child. So intimidation is any act or gesture that creates fear to the woman or to the child. For the next classification of abuse or violence is sexual violence or sexual abuse. Based from the law, sexual abuse or violence pertains to an act which is sexual in nature, such as rape and sexual harassment. So RA 9262 provide for the specific acts under this classification of violence or abuse. Number 1, we have rape, sexual harassment, acts of lasciviousness, treating a woman or her child as a sex object, making demeaning or sexually suggestive remarks, physically attacking the sexual parts of the victim's body and others. Treating the woman or her child as a sex object means that you only need the woman or her child to satisfy your sexual desires. Making demeaning or sexually suggestive remarks, physically attacking the sexual parts of the victim's body, pertains to any demeanor or remarks that have sexual undertone or connotation, constitute a sexual violence, or an assault in any sexual part of the victim will constitute a sexual violence. Next, acts causing or attempting to cause a victim to engage in any sexual activity by force, threat of force, physical or other harm, or threat of physical or other harm of coercion. In here, to constitute a sexual abuse, there must be the use of force, the threat of force, physical harm, or threat to inflict such or coercion in engaging in any sexual activity. So the third classification of violence or abuse is psychological. Psychological violence is any act that causes mental or emotional suffering to the victim, such as intimidation, repeated verbal abuse, marital infidelity, stalking, and others. So under the law, we have the following specific acts: engaging in knowing or reckless conduct personally through another that alarms or causes substantial emotional or psychological distress to the woman or her child, including stalking, peering in window or tinitingnan mo siya sa labas sa magitan ng pagtingin sa kanilang bintana ng kanilang bahay, lingering outside the residence, entering or remaining in the house or on the property of the woman or her child kahit na pinapaalis ka na. Number 4, destroying property and personal belongings or causing harm to animals, pets, especially in the presence of the woman or the child. And lastly, engaging in any form of harassment or violence. Next, causing mental or emotional anguish, public ridicule, humiliation including repeated verbal and emotional abuse. Specifically, under this second act, we have these specific acts. You putting the woman, putting her down or putting the woman down, such as emphasizing that she's not good in anything, making her feel bad about herself, or any act or any word that make her lose her confidence, and calling her names, making her think that she is crazy, and then humiliating her or making her feel guilty into something, especially putting all the blame on her all the time. So those are the specific examples of emotional abuse under psychological violence. And then the last classification of abuse or violence is economic abuse. So there are two specific acts. The first one, acts that make the woman financially dependent, such as withdrawal on financial support, destroying household property and others, and preventing the woman from engaging in any legitimate profession, occupation, business, or activity, or controlling the woman's or the victim's own money or properties, or solely controlling conjugal or common money or properties. So these are the specific acts or examples. Preventing her from getting a job or keeping her a job. Number 2, making her ask money from you or from the perpetrator. Giving her an allowance, making her financially dependent. And then the last one, taking her money and not letting her know about or have access to family income. So based on survey, up to 70% of women worldwide experience violence in their lifetime. For the victim survivors, these are the specific rights that they can exercise. So number 1, they have the right to be treated with respect and dignity despite what they have despite what they have experienced in the hands of their perpetrator. Number 2, the right to confidentiality pertaining to their case. Next, to avail of legal assistance from the POW or any public legal assistance, especially if the victim already filed a case against the perpetrator. And then the next one, to be entitled to support services from the DSWD and LGUs while the case is still ongoing and while the woman is under distress. To be entitled to all legal remedies and support provided by the Family Code. And then the last one, to be informed of their rights and the service available to them, including their right to apply for a protection order. If you happen to be a victim of violence against women and their children, these are your legal remedies. So the first one, you file a criminal action against the perpetrator. Number 2, you file a criminal action but you can reserve your civil action against the perpetrator. Or instead of seeking criminal action, you can file a civil action for damages. And then the last one is you apply for protection order without claiming damages. So for your protection as victims of VAUSI, you can file for protection order, so you're considered as the offended party. In case of the child, we have the parents or the guardians of the offended party. In the absence of the second one, we have the ascendants, descendants, or collateral relatives within the 4th degree of consanguinity or affinity. And in the absence of relatives, we have the officers or social workers of DSWD or social workers of LGUs. We have also PNP or police officers. And then we have the punong barangay or the punong kagawad. And then we have your lawyer or the counselor. We have also your therapists who can file for the protection order. And in the absence of those, at least two concerned responsible citizens of the city or municipality where you reside. So these are the three classifications or types of protection order that the offended party can apply. So the first one, we have the BPO or the Barangay Protection Order, which is issued by the Punong Barangay, and it is effective for 15 days. Then the second one, we have the TPO or the Temporary Protection Order, which refers to the protection order issued by the court on the date of filing for the petition, and that such order should be issued and effective for 30 days, and it could be renewed or it can be extended. And then the last one, we have the PPO or the Permanent Protection Order, which refers to protection order issued by court after notice and proper hearing. Okay, so these are the purposes now of your protection order. So the first one is to prevent further acts of violence against a woman or her child, lalo na hindi ka malalapitan ng perpetrator or the suspect, and to safeguard the victim from further harm, minimize any disruption in the victim's daily life, especially if the violence committed is more on psychological, and it facilitates the opportunity and ability of control over her life. For violation of RA 9262, these are the penalties that could be imposed. So the first one, we have imprisonment. Then the second one, we have fine. And then mandatory psychological counseling or psychiatric treatment for perpetrators. Okay. So these are the sources for the topic of today. So we have the law itself, and then we have also a PowerPoint that was taken from the internet. Thank you, and keep safe, everyone.